So what we're going to do today is we're just going to go over, it's not very exciting. Sorry, guys. We're going to go over the 1 to 4 contract. And is that what you guys are looking at now?
Yes.
Okay, perfect. And we're just going to walk through the terms. And this is the updated version 1, which you guys can tell. So the changes were made in November of 2022. It's required to be used starting February 1st. So this is the new form. It's not drastically different. I think there are some good changes. So we'll just walk through it. Okay. And then next week, we're doing the actual form updates where we'll go over like all of the forms that they changed. What we'll do is just go over the changes. In this class, we're going to go through the whole contract. Good?
Good.
Any questions? No? Okay. Perfect. I don't want this to, I'm going to talk fast because it's a lot to get through. If you have questions or examples that would help, speak up, because you guys definitely learn best from each other rather than me. So here we go. Okay. Parties to this contract are blank and blank. Obviously, if the listing agent hasn't told you who the seller is, you can look it up in the county tax records, right, to stick that in there. And, you know, on the listing side, I always tell you guys, if it's a situation where you're not 100% sure who the seller is, or it's an estate, or, you know, it was inherited or something like that, I always encourage you to go to the title company, ask me and Randy to help you. We can look up and just confirm who's actually the record owner, because it's one thing to sign a listing agreement with the person maybe who's not technically or one of the two parties. And then, you know, that's one thing. It's another thing to sign a contract with a third party. And if your seller is wrong, that's a huge problem. I did that once. I put a investment property under contract and we got to like 2 days before closing. And the title company was like, oh, sorry, there's like 8 heirs here who we can't find. And it was like, cool. That was really frustrating. So that's a good tip to make sure you have the right seller. Okay, so property. You know, what are we selling? The land improvements and accessories, lot and block. That'll be in the tax records, which subdivision, which city, which county. This is the street address, you know, and then 2B and 2C. This is probably one of the like most frequent calls I get. I see Jennifer's nodding. She agrees, because it's always like you're about to close and there's some issue that people are fighting about, right? Does this go or does this stay? Because the seller wants to take it and the buyer says it stays. And the contract is pretty clear, and it's gotten much better recently about what is included. So the first thing what happens when you guys call us is Jennifer and I are going to point you guys back to this paragraph and be like, okay, let's go through and reread it and then see. And most of the time, like, it's covered in here and it's pretty clear. So just be mindful and have your clients read this paragraph so that they understand what they can take as the seller and what they're going to get as the buyer. Okay. The language is always right there. We got to look at the 4 corners of the document. Okay. So exclusions, this is anything that the seller is going to keep, you know, like their favorite mirrors in the bathroom, like the family heirloom chandelier, like whatever it is. If you know that the seller is going to take something, even if you put it in the MLS, it must be written in here as well. Putting it in the MLS as an exclusion means nothing. It needs to be in the 4 corners of this document, right? So you have to write it in there. I would always advise you, if it's something that's super precious to the seller, just remove it before you put it on the market, right? Then the buyer sees what they're getting and there's no like surprises there. That's my best tip, I would say. Okay. And then reservations, any reservation, you know, will be made in accordance with an addendum. This is not where you write minerals, right? Please, please, please do not do that. You guys know better than that, right? If the seller wants to reserve the minerals, you need to attach the mineral reservation addendum. So any questions so far? This basic stuff. Okay, good. So sales price. So this is where there's a change, and this one is probably relevant to you guys. So, you know, cash portion of what they're paying, sum of all financing, these are the options, and then what's the total sales price. But you'll see this new sentence here. The term cash portion of the sales price does not include proceeds from borrowing of any kind or selling other real property except as disclosed in this contract. So basically, they're trying to prevent the situation where you say it's cash, but you're getting a loan, right? And I would say that happens. It happens, definitely. I get calls about that too. And the buyer thought they were going to pay cash, but then they were able to get really favorable terms. And I always say, just go ahead and let the listing agent know, so there's no surprises, because you know they're going to get a call about the appraisal, right? And you don't want to be like, oh, well, we tricked you. We had one recently where it was our listing, and we think the buyer's agent kind of did just trick our listing agent and seller and kind of lie and say, oh, it's cash. And then it wasn't cash, and it like delayed, and it was a big, huge ordeal. So they're trying to prevent you guys from doing that, and saying you need to say if there's going to be financing, right? So that's what that looks like. This isn't exactly clear because you may be getting like there may be a person who's like, I could pay cash, but I'm going to get a loan, so I don't need the financing addendum because there are no contingencies, right? That could be the situation. So I think what you're going to have to do in this situation is use a third-party financing addendum, waive that the buyer has to qualify, right? You have two choices, whether it's contingent on the buyer qualifying or not. So you're going to waive that, and then you're going to do the appraisal waiver also. I think that's how they want you to handle it. If it's like, you know, they're getting a loan, but there's no contingencies on it. Does that make sense? Call me and we can walk through it. But I think it's a good attempt to stop people from trying to trick you into saying it's cash when it's not cash.
Zareen, what if they're just borrowing from another account? I mean, that doesn't really matter, right? Like say they're taking out of their 401k or what have you to.
Yeah, I mean, I think that's still cash. There's not like a third party involved who's going to be getting an appraisal or anything that would like create contingencies, I think. It's a good question. Okay, so that's our first change. So then, paragraph 4 is leases. This was new in the past couple of years, except as disclosed in the contract, seller's not aware of any leases affecting the property. After the effective date, seller may not, without buyer's written consent, create a new lease, amend an existing lease, or convey any interest in the property. So this is where the seller is going to say, like, yes, there are some leases in place on the property. We have some investment properties that we're going to sell, hopefully with leases in place. So we would check this box, and then you can see it's subject to one or more residential leases. And there's an addendum that we would attach. And in that addendum, it explains you have to deliver a copy of the lease, and you have to kind of make a few statements about the lease so that the buyer knows what they're getting, because the property is being conveyed encumbered by this lease, right? It's not like the lease ends when the property transfers. Like the buyer, the tenant still has rights in their property because of their lease. So the buyer is just taking it encumbered by that lease. Does that make sense? Yes. Okay, good. And then, fixture leases, this was a good addition because, people have solar panels, propane tanks, et cetera, et cetera. So there's an addendum now that you use if those are on the property, and that helped clarify a lot of confusion. We had a lot of confusion with solar panels, I would say. And then if there's a mineral lease in place, you have to disclose that, and you either have to deliver a copy of the lease or before, or deliver it at some point. And a lot of people that are just getting mineral royalties maybe don't have a copy, so they'll have to track down the person that's paying them and get a copy. So questions? No?
Green, I'm seeing agents getting confused on the lease. They're checking it if it's a seller leaseback.
Oh yeah, no, that's a perfect point to make. This has nothing, this is if there's an existing lease in place, right? Yeah. This is not for a lease back. So that's a good point. But only if there's like a different lease in place with a third party here. Good point. Okay, so paragraph 5, there is a change here. It's not a huge one, but it's an important one. So see where it says escrow agent here with capital E, capital A? That's what's called a defined term in the contract. And that way, whenever they refer anywhere else in the contract to the escrow agent, it's capital E, capital A, and it's been defined who that is. So not a huge change, but like an important one as they refer to it throughout the contract. So within 3 days after the effective date, buyer must deliver to blank, hopefully momentous title, at 3131 Turtle Creek, Suite 100. And then, here is your blank for the earnest money, and here is the blank for the option money. I will tell you, so that you guys do not ever do this. When this form was new, we had an agent who switched, and she put $500 earnest money and $20,000 option fee. And that money was lost because the buyers terminated, and then they tried to unterminate, and the listing agent was like, nope, and it was a windfall for the seller. So please, please, please be careful to not switch those and like triple check that. I know you guys are good, but I have to tell that story. So,
Serene,
yep.
so it's not the escrow agent, like the literal name of the person, it's the name of the company and then the address, right?
Yeah. And that's a great question. You could put, Momentous Title, Randy Ramirez, or, Republic Title, Kyle Ramirez, or whatever you would want to say, if you wanted to go to a specific person on the contract, but you also usually just send the contract to the person you want to close it. Does that make sense? Yeah.
Yeah. I just was confused because I thought it was the actual by escrow agent. It was the name.
Yeah,
of the agent.
that's fair. I would put the title company name, and you could put, Momentous Title / Randy Ramirez if you wanted, but more importantly, it's the company, I would say.
But I think most people want to see the closer's name because some people have, issues. They don't like certain closers, or there's a certain closer they're tied to. So, I mean, I always put the person's name.
Yeah, but I would put the company name as well.
Oh, yeah.
Otherwise, now that it's a defined term, like they're on the hook for all of these things. So making sure it's the company and the person is a great question. So whatever, Benchmark Title, Allie McAtee, right? Like that's a good way to do it. Just put a / Perfect. Okay. So then, if they deliver additional earnest money, you can put that here within however many days. Oftentimes you guys use this if you're in backup and you only want to put down additional earnest money if the first one terminates and the date that the first one would either move forward or not. So then if this is when we still get questions on, if the last day to deliver the earnest money option fee or additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. So if something is due on Saturday or Sunday or a legal holiday, it's really not due until the next business day. That makes sense? Okay, but this does not say that if during your 3 days, it's, say you put something under contract on Sunday, October 10th, and then Monday is the day we take off for Columbus Day. That doesn't mean that you don't count that day because it was a holiday. That day still counts. It's only if it ends on a holiday. Does that make sense? Okay, we get that question sometimes. Okay, so the amount received will be applied first to the option, then the earnest, then additional earnest. Buyer authorizes escrow agent to release and deliver the option fee to seller at any time without further notice. That's basically saying once you send the option and money, it's gone, which we all know. Okay, so termination option. This used to be paragraph 23, and now they tucked it under here, which I think was a good change last year. So for nominal consideration, the buyer agrees to pay this option fee, and seller grants the buyer the unrestricted right to terminate by giving notice of termination to seller within blank days. So that's the length of your option period after the effective date. And notices under this paragraph must be given by 5. Although it looks like, that kind of looks like you can change it, but no, I think it's 5 p.m. Local time where the property is located by the date specified. Buyer gives notice of termination within the time prescribed. The option fee is not refunded. So the option fee goes to the seller, but the earnest money goes to the buyer. Any questions about that? Okay. Failure to timely deliver the earnest money. So if buyer fails to deliver the earnest money within the time required, seller can terminate or exercise their remedies, or both, by providing notice to buyer before buyers delivers the earnest money. So the way that this works is, say your option money is due on Tuesday and the buyer hasn't delivered it. That means after 5 o'clock on Tuesday, the seller has the right to terminate. And the reason that they did this is it happened a lot where investors would write a contract with no option, but they'd only put $1,000 earnest money, and then they would never deliver their earnest money until after they had done inspections. And it wasn't fair because as the seller, you were tied into a contract. You had no right to terminate, but the buyer hadn't performed. They hadn't delivered earnest money. They were performing inspections, even though they had pretended like they were. It just wasn't fair. So now this gives the seller the right to terminate if the buyer doesn't perform and deliver their earnest money in a timely manner. Does that make sense?
Yes.
Okay. So then failure to timely deliver the option fee. If no dollar amount is stated as the option fee, or if the buyer fails to deliver it within the time required, they don't have the right to terminate. That's pretty clear, right? If you deliver the option fee late, technically you don't have the unrestricted right to terminate. So that's super, 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 super important. Okay. That the option fee gets delivered on time. There's no fixing it. Oh, and then one thing with respect to failures to timely deliver the earnest money, I always say like it's a race. If the buyer doesn't get it there on time, but this happened to us the other day where the buyer they thought they sent a wire, but they sent an ACH and it wasn't there and it wasn't there. And arguably, if the seller had wanted to terminate before the money got there, they could have. If it turns out to be day 4 or day 5 and the buyer delivers the money then and the seller hasn't terminated yet, the contract will continue. But it's kind of a race. Once the deadline to deliver the money has passed, it's a race for either the buyer to deliver the earnest money and the contract to continue or the seller to have the right to terminate. Does that make sense?
Mm-hmm.
Okay, perfect. Okay, so then E, you'll see here time. This is in bold and conspicuous language here, bolded like this. Time is of the essence for this paragraph and strict compliance with the time is required. That means that like all of these deadlines and dates are hard. There's no like wiggle room. Like interestingly, in this contract, like closing is not an of the essence provision, right? This time is of the essence only applies to paragraph 5. So if someone doesn't hit the closing date exactly, it's not like automatic default, arguably, in Texas because we don't have time of the essence. Does that make sense?
Mm-hmm.
Okay. Okie doke. So title policy and survey, there's no changes here. In paragraph 6, let me make sure that that's correct. Well, that's not true. In 6D, we get some. Okay, so title, seller shall furnish to buyer, and this is negotiable. Technically, the seller can't force a buyer to use the title company that they want, but whoever's paying it does have the right. So if buyer wants a specific title company, they should pay for it if the seller's not budging. But it's a violation of RESPA to require a certain title company to be used. So issued by hopefully Momentous Title in the amount of the sales price at or after closing, ensuring buyer against the loss under the provisions of the title company. And then these are the standard exceptions that you're going to see in Schedule B of the title policy, right? It's the same like boilerplate language. And then paragraph 8 here, you have to explain to your client what this is. And what this is, it's asking you whether your buyer wants an additional endorsement to the title policy that would basically provide them some extra coverage. So there's a standard exception that says that the title company is not going to cover discrepancies or conflicts, shortages in area or boundary lines, encroachments, et cetera, et cetera. The title company is saying up front, like, we don't cover that. If the buyer wants coverage for that, then you say, yes, we're going to check this box. We do want it to be amended to read shortages in area only. So that's the only thing then that the title company won't cover, and they will cover the rest of these things if you pay for this additional endorsement. Does that make sense? Yes. So basically, it's like an add-on to the insurance policy, right? This endorsement. So if your buyers want that, you have to explain that to your buyers and say, do you want this or not? And if they're going to ask you, I mean, what is your opinion? You don't want to be, they have to decide. I don't want to be the person that says, oh, you don't need that. And then in 3 years, there's a boundary issue that they don't have coverage for, right? It's not a huge expense. It's 5% of the total premium cost. So if you ever want to know how much it is, we have a title calculator on our website, or you can just call me or Randy, and we can tell you the number of how much would that actually cost. And then it's negotiable who is it, buyers or seller. And that, depending on the market, obviously for a while, and that crazy market we just had, buyers were paying for this if they wanted it. Now it can be like more of a negotiable term. Any questions there?
Can you explain the gist of that again, Zareen? It went by really fast.
Yes, I know. I talk fast. I listen to all of my podcasts and Audible on 1.5x.
We have found total acres before, so on the survey. So this is really interesting to me.
Yeah, I mean, I would absolutely, especially if you're buying ranch and land, I would ask for this endorsement just because it provides extra coverage. Basically, it's a standard exception, meaning that the title company is saying to the buyer in the commitment, we will not cover these things. Okay, this is not included in the coverage we're giving you under your basic policy. If you want extra coverage for these things, then you need to check box 8.2. saying, I want to pay extra so that all of these things are covered. And they're saying the only thing that won't be covered is shortages in area. And Angie, if you do want that type of coverage, there's probably I'm not like an actual title closer. Randy would know the answer to this better. I'm sure there's an endorsement to cover whatever you're looking to cover. You just have to ask, because there's all sorts of endorsements you can buy to add to your title policy, right? This is one of the most frequently used ones, so they added it to the contract. Does that help?
Yeah, it does. And that's, how does that work with the survey? Like if they've already had a new survey, is it necessary?
Well, so we're gonna get to that. I mean, if there's an error in the survey, then you don't have coverage, because what the title company is ensuring is what the survey shows. Now, if there's a problem with the survey, that's on the surveyor, right? And that's what the title commitment says. When you look at it, it references like the existing survey. That's why I always recommend, and we'll talk about this, that your buyers get a new survey of a property, because it makes the policy so much stronger, especially if you're buying ranches. I would say get a new survey. I know they get really, really expensive because they're like, meets and bounds, and someone has to go out there and like find every stake in the ground. But when I was a lawyer, that's how you're ensuring that like they know what the boundaries of their property are and they have coverage to protect it.
Okay, I got it.
Hey, Zareen,
yes.
Buying ranch land, it's really important when you're purchasing typically offers are made price per acre in our circumstances. So you're recommending that you get an endorsement that covers shortages? Is that what you were saying?
Well, no, what I'm saying is that this endorsement here covers all of these things except for shortages. You can see it will be amended. The exception is amended so that it only says shortages in area. If you want coverage on that, I would assume, again, I'll have to check with Randy and I will circle back to you guys and let you know if there's even coverage for that. But the farm and ranch contract is going to address this in more specific detail. So if you're doing a farm and ranch contract, you shouldn't be using this form anyway.
Yeah, right? It has some different wording, but
yeah,
I'm just, okay.
It's different.
Okay. But then if you get a survey, you'll see it and then you can object to it if it doesn't match.
Yeah. So for the rest of you guys that don't deal in farm and ranch contracts all the time, like they do sometimes pay per acre. So there's like a whole separate section about that and if the price will be adjusted. And anyway.
Thank you.
Okay. So commitment. So within 20 days after the title company receives a copy of this contract, seller will give buyer a commitment. And basically when they get the contract, if they haven't already opened title, they're going to pull title and see what all encumbers the land. And then they're going to deliver a commitment to everybody that says, this is what's encumbering the land, right? And Schedule B is going to tell the buyer, these are all the things we're not going to cover, right? And it's going to be those 8 standard things or 9 standard things. And then the things that are specific to the property in paragraph 10. And then Schedule C is going to tell the seller, these are all of the things we have to clear up before we can give clear title. And it's going to be any existing mortgages. If there's a divorce, like make sure that they're following the terms of the decree as they dispose of the asset. Like there's all sorts of things like that the seller has to look at Schedule C, the buyer needs to look at Schedule B. So, but basically this is saying, they're going to deliver a copy of the commitment and all the exception documents, which if they say that these certain things affect the property, they're going to give you copies of those underlying exception documents so that you could kind of see, the original plat that shows the setbacks or whatever it is. So if they're not delivered within the specified time, the time for delivery is automatically extended up to 15 days or 3 days before the closing date, whichever is earlier. If the commitment and exception documents are not delivered within the time required, buyer may terminate this contract and the earnest money will be refunded to buyer. So if you get to 3 days before closing and you still don't have a commitment, the buyer has the right to terminate. Or if it's 15 and 20, if it's 35 days past the effective date, the buyer has the right to do that as well. Because it probably means there's some like complicated title things going on. Does that make sense? Okay, survey. So, this survey must be made by a registered professional land surveyor. And then you have to check the box, does the seller have an existing survey and can they furnish it with an affidavit? Or is the buyer going to get a new survey? Or is the seller going to get a new survey? Like who's paying for it? So if you typically hear the seller has one and they are going to deliver their existing survey together with an affidavit that has been notarized that says, here's the current survey. And the affidavit says, these are any changes that we've made since this date that we're aware of. Like the first deal that I ever did, the survey showed a hot tub and the seller had removed the hot tub. So he had to say like, removal of hot tub is no longer there. And then the title company and the lender will both look at the survey and the affidavit and say, this is still a good survey. Like it's still current enough that we can use it, or we need to start over. Like if the original survey is just a house and the seller says, oh, well, we added a back house and that's the survey and the affidavit together, the title company is probably going to say like, no, we need a new survey that actually shows that back house that you added to make sure there's no huge crazy issues. There's not like way over the boundary or anything like that. Does that make sense?
Yeah. Last fall, I had a situation where the title company would not accept a survey, even though it wasn't really old, because the surveyor was known for making mistakes and had actually gone out of business. So yeah, FYI.
Yeah. And realistically, I think that title company is doing a good job protecting protecting the buyer, because even though the buyer may have to pay for a new survey, then depending on which box you guys checked down here, it makes the policy so much stronger if the survey is correct, right? Because the title company is saying we're ensuring what's on the survey. So I always tell people, especially when you guys are dealing with like super high dollar assets and homes, I think it makes sense, unless the survey is very, very new and the seller is like, we moved in a year ago and we have changed nothing. I think it makes sense for the buyer to pay for a new survey, because then if the surveyor made a mistake, the buyer has privity of contract with the surveyor, meaning I paid this surveyor and we were under contract together and you did a bad job for me. And then you can go after like the surveyor's E&O as well. Does that make sense? That's my recommendation. If you guys are selling there's no reason to cheap out on a survey if you're selling a like luxury property. It doesn't make sense. Yeah. Okay. So one thing to point out, and this is in, bold and conspicuous language for all of us, which always means we should pay attention. If seller fails to furnish the existing survey or the affidavit within the time prescribed, buyer shall obtain a new survey at seller's expense no later than 3 days prior to closing date. So this is why it's our best practice at Briggs Freeman that you upload the survey and the notarized T47 as part of your listing paperwork, and it goes into the MLS, because a lot of title companies will say, oh, well, we can just notarize the affidavit at closing. Like, please do not do that. If anyone says that to you, that's terrible advice, because technically the buyer could call the title company after this whatever day and say, get me a new survey at the seller's expense. And guess who usually ends up paying for it? Like the agent, right? Because the clients don't read this language that closely. So please, please, please make sure that your affidavits are notarized and included in the listing paperwork, so that it's not a stress once you go under contract to like hustle for that. Brandy's a notary. I think everyone who sits at the front desk in our offices is a notary. If their bank is going to have a notary, like there's notaries everywhere. It's really important. I don't want you guys to have to pay for surveys. Okay, questions there? Bess, what's up? You can just unmute and shout it out.
Oh, I just wanted to make a comment as far as writing a winning strategy offer. This is one of my favorite stealthy deals. When I've checked MLS when I'm representing the buyer, and I see that the survey and the T47, or just the survey, has been uploaded and not the T47, I do like to check this and check buyer's expense, because most listing agents think they've already gotten their homework done, and we look stronger because we're a buyer. Hey, we're here to play well with others, and we'll just go ahead and buy a new survey if needed. They eventually sometimes get the T47, but they usually miss this deadline. So if it is kicked out, then my buyers get their new survey, which they want, and they're not paying for it. Got a house closing on Friday, and my buyers are getting a $700 survey for free because of this little deal.
So you checked that the sellers would pay for it?
I checked that the buyers would pay for it, the new survey. Mm-hmm. And however, the seller never provided a T47. So when the survey was kicked out, and it was interesting because the title company at first said, hey, y'all need to authorize a new survey and we needed a credit card or whatever. And I was like, well, actually, we'll take the survey, but we're not paying for it.
Gotcha. Yes, that's a good catch. Yeah. And so you guys being aware of that is like an arrow in your quiver on behalf of your buyers, right? If you get the survey and not the notarized affidavit, then technically the seller needs to buy you a new survey. Okay, so good point. Okay, so then objection. So this part gets confusing for you guys. And basically what you need to know is that when the buyer gets the title commitment, they can review what the encumbrances are on the property in Schedule B, Item 10, to see what is the title company saying they're not going to cover. And it's going to say things like, you know, easement, setback, you know, mineral reservation sometimes. But if the buyer is like, I was wanting to put a pool in this property and there's a big, huge pipe easement in the backyard, they can object to that and it gives them the right to terminate. That's probably not something that the seller is going to be able to cure. We've had one before where the buyer wanted to build a property and they build a house and they already had plans, and the plans like went over the setback. And so the seller actually applied to the city for a variance and they got it. So then that was an objection the buyer had made and the seller was able to cure it. So that's just the kind of thing that you guys will see. A lot of times you people put like single family residence here, like that's not really necessary. It's only if you know your buyer has an intended use, like if they want to use it as rental property, you could put that in here because maybe some HOAs prohibit that. Or if they wanted to add a pool, or they knew they wanted to build a 10,000 square foot house, like those are the kinds of things that can go in here. Typically it can stay blank, I would say. And then here, you know, in this blank, the question is, you know, if you represent the buyer, you want to give yourself enough time to review the commitment and make it objections if necessary. If you want the seller, you want that to be as short as possible, right? Because you don't want the buyer to have a ton of time to make objections. So on as a buyer, I would probably put, you know, 7 days to see what the seller says, and maybe they'll negotiate back and maybe not. As the seller, I would want it, if they leave it blank, put like 2 days or 3 days, you know, put a small number in there as the seller. Does that make sense? Bess is saying that there's places in Dallas where you can't add a second story. So you could, if you knew your buyer wanted to buy this house and add a second story, you could write that in there. Sylvia, you had a question about the T47. Do you want to?
Yeah. Yes. Can you hear me?
Yeah.
Okay. So I had a deal recently that's where I had the buyer, the sellers had uploaded a survey, but then had drawn on there where they had done an outdoor kitchen. So we knew that the buyer was going to have to pay for a new survey, which is the box that we had checked because it did not include the outdoor kitchen. However, the T47 they submitted did not have that they had added the kitchen. So I pointed out to her that that was incorrect. She since has sent a correct one, but now, and I'm going to double check my dates, pretty sure that fell outside of the 3 days, or excuse me. Yeah, the 3 days. I mean, so other than being sneaky.
Yeah, I mean, that's not really addressed here. So I would just say you're updating the T47. Like you delivered it, it just needed to be updated, right?
Okay. So I can't really go back on them and put the new survey cost on them since they missed that deadline.
Well,
I'm the buyer. I'm not the seller.
If you're the buyer, I mean, then you could say, no, you know, like you were supposed to deliver this to me and you didn't. The one you delivered to me was not complete. It was an incomplete one. That doesn't count, right? I mean, this is being a lawyer, right? It's like, what argument do I need to make? And then go either way.
Right.
It's not black and white for either side within these four corners. So I think you could argue that you deserve a new one. At the seller's expense.
Yeah.
I have a question on this one as well, because Bess, I thought that was genius in regards to what you previously said. However, I'm rereading it and it says if seller fails to furnish the existing survey or affidavit within prescribed time. Since it says or, it doesn't say and. So if you get the survey, and did that change? Because I want to say at one point it used to say and.
It's both.
Read the line above it, Lori.
Yeah.
Okay. So it is both.
It is both. Yeah.
Even though it says or.
But I would say, but if it says or, it means either or.
That's what I would read to believe.
So
because I love Bess's point, but then I was like, well, wait.
Have a copy of the old one because it used to say and.
So listen, if you guys look at one, you have to read the sentence above it. It says the seller will furnish to the buyer the the existing survey and the T47. What the bolded part and Bess's point is, if they fail to deliver one or the other, they have to deliver
no, I
both.
got her point. I just
Gotcha.
I just missed the and up top, I guess, because
yeah.
All right. Okay, now I got you. Right.
And
Thank
up
you,
top. I
Jennifer.
loved her point.
Yeah. Okay. Good deal. All righty. So, and if you get into a situation, this is one of those, Angela teaches a class that we just got CE approved called Legal Ways to Exit the Contract. This is one of those situations. When your buyer looks at Schedule B, if there's things that they don't like, call me or your manager and we can kind of walk through what their options are and if it's something that they can really object to. If it's a buried pipeline in their backyard, like good luck, the seller's not going to be able to cure that. But if it's like, you know, a setback required by the city, they may be able to apply for a variance. So it's things like that. Okay. So, and basically, you know, the buyer delivers objections and then the seller has a certain amount of time to cure. And if the seller doesn't cure, then the buyer has the right to terminate or waive their objections. There's like a whole process that we kind of walk through when we get into this situation. Okay. So title notices. Oh, and this is actually in subjections. This is where one of the changes was. It used to be capitalized survey and now it's not capitalized anymore. That's kind of a garbage change. I think that was just a mistake because survey is not a defined term anywhere, but it was capitalized down here. That was like the lawyers being nitpicky. Okay, so title notices, broker advises buyer to have an abstract of title, covering the property examined by an attorney, or buyer should be furnished with a title policy, which we're going to do in Texas, although it's not required on a cash deal. Lenders are going to require it, of course. If a title policy is furnished, this is good for us to know this is in the contract. The commitment should promptly be reviewed by an attorney of buyer's choice due to the limitations, due to the time limitations on buyer's right to object. So to be clear, it is not our job. We are not attorneys to write objection letters. If there are things that we object to, we need to pull an attorney in. Okay. So please reach out to your manager. So we will keep going. Okay. So, you know, this property is or is not subject to mandatory membership in an HOA. You know, if it is, then these are like required notices that they're giving. And this is just in bold, conspicuous language so that buyers understand that if you are buying a property in an HOA, you will be required to pay assessments. They don't want anyone to be surprised. They just want this to be like in the contract so that the buyer is on notice. And then this says, section 207 of the property codes entitles an owner to receive copies of any document that governs the establishment or maintenance of a properties association. A resale certificate contains information about the owner's association. These documents must be made available. If buyer is concerned about these matters, the TREC promulgated addendum for property subject to mandatory membership in a property owners association should be used. So basically, this is saying if the property is subject, then you need to attach the property owners association so that your buyer gets all of that information. Questions? Okay. So then this is just, you know, these are boilerplate disclosures about statutory tax districts, tidewaters, annexation, property located in a certificated service area of a utility service provider, PIDs. We're going to do like a whole separate class. One of you guys asked this, so we're building it right now on like PIDs and MUDs and all of the things, because I know it's really confusing. So it's its own whole class, but these are all just notices that the seller has to give the buyer. So they built them into the contract. And then here, this is new, this section 11. Now there are required notices for MUDs and PIDs and these things. So you have to say the following notices have been given or are attached if the property is in one of these. In theory, your seller should know if the property is located in one of these because it's going to be on their taxes. And then you have to give the documentation about that. Okie doke. Okay, so paragraph 7, the first few paragraphs have not changed. This is an important one that a lot of you guys don't realize. Seller shall permit buyer and buyer's agents access to the property at reasonable times. It does not say one time for inspections, right? It also does not say every day, all day, so that you can meet with your designer and talk about paint colors, right? Like it's reasonable access at reasonable times. the seller has to give that. Like they can't refuse to let you do a walkthrough prior to closing. And if they do, you need to point out this paragraph and ask to talk to their manager and call your manager and get us involved. But it's very clear in the contract that the seller has to give buyer and their agents access at reasonable times. Again, is going there every day for 5 hours with your designer reasonable? No. Is going there for a walkthrough and a couple of times for whatever you need reasonable? Probably so. So that's just to figure out. Okay. Hydrostatic testing, we know, must be separately authorized by seller in writing, and there's a form for that. The seller's disclosure, as you guys know, it's our best practice on our listings to have the seller's disclosure filled out with the listing paperwork so that we can provide it, so that this box is always checked on our listings that the buyer has received the notice. Because if you put it under contract and buyer hasn't received the notice, you have X amount of days, whatever you put in there, to give it to them. And then you will see that, when seller delivers a notice, buyer may terminate the contract for any reason within 7 days after the buyer receives the notice. So you're giving the buyer an automatic 7-day option from the date that they receive the seller's disclosure if you don't have this box checked. Does that make sense? Yes? Like there's zero reason on our listings that we would check this, because we're giving them an automatic option of 7 days, and even longer than 7 days. Because if it takes you 5 days into the contract to deliver the seller's disclosure, then they have another 7 from when they receive it. Does that make sense? Bess is asking, is receipt of notice considered uploading to MLS or only if emailed to agent? I mean, I don't think putting something in the MLS can constitute delivery of notice. So I would be proactive and email it to them. You can argue about it, but I think if you have checked this box and we haven't sent it to them, then we haven't delivered it. I guess, Bess, you were in the situation where the listing agent said, well, it was in the MLS, so you had it. And if that's the case, then that box should have been checked from the get-go, right? When you went under contract. So lead-based paint is in the same category, she says. Okay. And then here, seller is not required to furnish the notice. There are very, very narrow, very small number of very specific exceptions. 5.008E of the Texas Property Code that covers when the seller is not required. It doesn't matter if they're an investor, if they never lived here, if they've never stepped foot in Texas, unless they fall under one of those very specific exceptions, like they have to deliver it. So, even if they don't know, if they had a property manager, they're probably better suited to have their property manager help them fill it out so that their knowledge of the property condition is conveyed. Of course, I'm always going to say over disclose. Yes.
For disclosures, at one point we had shifted to where using Seller Shield is our recommended best practice, even though it's more of an abbreviated disclosure. Just curious, what is Briggs's position at the moment?
It is to use the Texas Association of Realtors form, which is the one that is used by Seller Shield. So some of you had access to the MetroTex form, which was longer. And there were actually some issues because it asks more questions than what is legally required. If the sellers weren't filling those out completely, we were opening ourselves up to more liability. So that's why we stopped using that form and switched to using the Texas Association of Realtors form. The Texas Association of Realtors form is actually beefier than what the Texas Property Code truly requires. If you want to fill out like the bare bones, what is legally required form, because you do have an investor that doesn't have a lot of knowledge, I would use the Texas Association of Realtors form, which meets the bare minimum standards of what is required by the property code.
Thank you. That's helpful. I had never heard that kind of last paragraph about kind of the risk portion. Thank you.
Yeah, no problem. And I really recommend you guys use Seller Shield. It gives your sellers the opportunity to buy coverage, and it takes the burden off of you of advising them how to fill it out. There's all sorts of bubbles that they can click, like question marks that they don't understand, and then Seller Shield explains. So I think it's great. Even my 70-year-old mom has been able to figure out how to use it. So that's my recommendation.
I just used it and it's amazing. I got everything on the first time. It was just perfect. And they are able to do it online and with very little explanation. So I highly recommend it.
Yeah. So Sharon is talking about the with respect to the notice. She says you should email it when they schedule a showing. And it doesn't have to be when they schedule a showing. It's just before you go under contract, they have to have received it. So, if you receive an offer and they've checked this box and said 5 days, you can counter and say, nope, we're checking this box and here it is, right? So that's usually the way that it goes down. Okay, so lender required repairs. I like to point this out. So unless otherwise agreed in writing, neither party is obligated to pay for lender required repairs. If they do not agree to pay for the lender required repairs, then the contract terminates and earnest money is refunded. And then one thing to note, even if there are lender required repairs and the seller is willing to do them, if the cost of the repairs is more than 5% of the sales price, the buyer can say like, this house needs too much work and I don't want it. So just something to note. Okay, so then paragraph F is a paragraph where some changes have been made. And I think you guys are gonna like this one. Like this is the new sentence. It's a modified sentence, but basically it's saying, seller will complete all agreed repairs prior to closing. They'll get any permits. That's new. So if a permit is required to complete that repair, they will get it. And they must be performed by people who are licensed. That's not new. Or if no license is required, people who are commercially engaged in the trade of providing such repairs. So I always use the example of sprinkler. Like you don't need a license to repair sprinklers, but the seller can't be like, well, I'm super handy and I fix the sprinkler all the time. Like they have to hire a sprinkler company. And then what this provides, which is awesome, and you guys already do this, but now it spells it out in the contract for agents that are not as good as you and don't do this. Seller shall provide buyer with copies of documentation from the repair person showing the scope of work and payment for the work completed. And then at seller's expense, which is new, will arrange for the transfer of any transferable warranties with respect to all the repairs and treatments to buyer at closing. So this new sentence, I think, is really, really valuable and helpful to us because I think you guys were used to operating this way and being first rate and not just saying, yeah, the repairs are done. You would say like, show me the receipts. We're going to go have it re-inspected, whatever. And now the contract provides that that's what the seller has to do. Hire someone who's licensed or operates in the trade commercially, and then deliver you their, completed invoice that shows what was done. So you know who did the work, you know who to contact after closing if it isn't right, et cetera, et cetera. So that was a really good change. So, environmental.
Is that saying, so if there's a foundation warranty that you have to pay for that, the sellers are supposed to pay for the transfer then?
It says seller shall arrange. Well, this is for any repairs and treatments, right? So that's if it's
okay, so it's not foundation.
Yes, exactly. It's not, if it's like an existing warranty, I don't think that that's true. It's a good question, but reading this language, it says transferable warranties with respect to the repairs and treatments. Does that make sense? Okay. All right, this is a disclosure. And then this is another change. Yeah.
Can I go back and ask a question about, sorry, this just came to my mind about the delivery disclosure. So I know you said if it's on MLS in the transaction desk, it doesn't count necessarily as delivery. But so my question is like, you have it in showing time, and so it's automatically delivered when somebody's showing, then that would be.
Yeah, I mean, the question is like, if we got sued and went to court, would we be able to show something to the jury that says like they got an email with it attached, right? It was delivered, versus they had to proactively go and look for it in the MLS. And I'm not even saying, guys, that is like settled case law. There may be case law out there that says, yes, putting it in the MLS is enough. I doubt it. So I would say like, we want some way to prove that we delivered it to them, whether it's an automatic email after showing like Susan suggests, but we need something to point to. We can't just say, well, they had to go look for it here. Okay. Right. I'm saying as a best practice, I'm not saying that I'm 100% certain that that's the law, but I would imagine that it is. Any questions? Someone was saying something, but I couldn't see who
Doreen?
it was. Yes.
Can you hear me?
Yep.
Okay, good. I can't hear you. I'm listening to you on somebody else's phone. For some reason. My question is that how do we know automatically? Are we supposed to know what things are warranted and which things are not? Obviously, roofs are warranted. In other words, what things would we specifically be asking for warranties?
I think you have to ask the seller and say, like, what do you have a written warranty for? Right?
Okay.
And then they may say nothing because they're not good at paperwork and they didn't keep track of anything. And then it's like, whoops, right? That's not a great seller, but it is what it is. So I think you have to ask the seller. And Jennifer, maybe you have something to add here. I would just say to the seller, do you have written warranties that anything that's transferable, especially if they're advertising like foundation warranty? It's like, okay, well, let me see it, right? What are the terms?
Right. Okay.
Yeah, I agree. And Zareen, there's some questions about still about the seller's disclosure. Okay. The best practice, what Zareen is pointing out, the best practice is when you execute a contract, the seller's disclosure is part of the contract and it's signed, and that that box that says the buyer has received the notice, right? If that's a part of the contract, it doesn't matter if you delivered it prior to the contract. It's about it being part of the contract. So if the buyers receive the notice and you have the signed seller's disclosure, that 7 days doesn't give them the extra 7 days. It's saying they've received the notice. So that part little 2 is not going to be checked, and it's not going to be, that's not, part of the contract at this point. You've already kicked that out. So the best practice is do not execute the contract with number 2 being checked. You want it to be checked with number 1, and you want to have the seller's disclosure signed by the buyer.
Right, exactly. So if this box is checked, then none of this applies.
Yeah.
Right. That's what Jennifer's saying. So that's why we say just get the seller's disclosure and the T47 completed when you're getting all of your listing paperwork. It's just part of seller's homework to get the property listing, is to get these things done. Then you have them to deliver, and there's no stress on the seller in terms of timing, and it's up to us as the quarterback to like deliver things in a timely way and make sure that this is filled out right.
That's why your wonderful OCs are trying to help you. They're not trying to make you mad, but like get your documents in so that you can you want to have as little outs of the contract for that buyer, right? If you're on the listing side. So this is just best practice. Occasionally we know sellers don't do it on the time frame and they push it, but just know you need to communicate to them that then that number 2 is going to be checked in their 7 days. But if you get a contract that has number 2 checked, 7B2, deliver the seller's disclosure. It's basically a counter. Just deliver it, make them check number 1, and get it done at the beginning. So I just wanted to make sure, because I saw there were a lot of questions.
Yeah, perfect. Thank you for watching that. That's exactly right. And this is good coaching for your sellers too. If they're like annoyed that they have to fill out all this paperwork during the listing process, you can say like, these 2 are really important, because if we don't have this T47 notarized, it's going to cost us some money because we have to buy a new survey. And if we don't have the seller's disclosure up front, we're giving the buyers an out. So we're sorry to make you do this paperwork, but it will make us, it's a strategic choice to have us have a better contract.
This is JB. I go ahead when I know somebody's sending an offer, if they don't do it blind, I resend that seller's disclosure, because we have to send the square footage, and nobody ever does the square footage. And it makes me crazy because we put it in MLS and they just don't do it. So I send everything they need to execute and remind them who the buyers are, because they always put the names in backwards, these junior Joes that aren't with the big names. And so it's just easier to resend everything that you need them to do, so that you're not counter offering to add documents.
Exactly. And I think that that's also being a good buyer's agent, is to go through the MLS, see what they have, talk to the listing agent, see what's needed, and deliver like a really good looking offer. Because what you're telling the seller and the listing agent is like, I know what I'm doing, and this is going to be easy, and we're going to get this across the finish line, right? Not like I'm clueless and my contracts are a mess. That's perfect. Thank you, JB. Okay, so this is one little change. It used to say just residential service company here, and they changed that language to provider or administrator licensed by the Texas Department of Licensing and Regulation. They defined what a residential service, what a residential service company is. So that's the only change there, of course. And then you can, I would have a home warranty person that you trust, so that you know exactly what coverage your buyer wants and you know the amount, or you can just guess the amount. And if the buyer doesn't, if the amount that the seller is going to pay for doesn't get the buyer everything they want, the buyer still can always pay extra to get the additional endorsements that they want. So, here's bold and conspicuous language saying that this is optional. Okay, so this is where they moved the section where we disclose, this was a couple contract changes ago, where we disclose whether we are a part owner of the property. And then we would just say, what is our relationship? Like listing agent is related to seller, whatever. listing agent is part owner of the property. You know, if you get into that situation, you want help with the language, just call us. So, okay, closing. So this is where I said, remember, nowhere in this paragraph does it say time is of the essence. So, and you'll note that closing is an on or before date. So you put, you know, your closing date here, or within 7 days after objections are made, under paragraph 60 have been cured or waived. So this also is built in. If you do objections and you're butting up against the closing date, this is like gives us some cushion. If either party fails to close, the non-defaulting party may exercise the remedies contained in paragraph 15. And then this says who's responsible for what at closing, right? There is nothing new in here except for that it says transfer of warranties here. So hold on, let me see exactly where that is. Transfer of warranties. So before it said all of the rest of this, this is the new language. Seller and buyer shall execute and deliver any notices. Transfer of warranties. So now the contract is acknowledging that. And this is a whole separate new provision for you guys to notice. So private transfer fees will be the obligation of seller unless provided otherwise in this contract. Transfer fees assessed by a property owners association are governed by the addendum for property subject to mandatory membership in a property owners. This probably helps the title company if they didn't do an HOA addendum and needed to. It's putting the obligation of the seller to pay any transfer fee. It's putting the obligation on the seller to pay any transfer fees, but it does say, if you have completed this document, you know, at the end of at the bottom of that, it says like, what is, if there are any transfer fees, I think it says buyers responsible up to X amount. That's one where, as the listing agent, if you get a property that's in an HOA, you need to figure out what are the transfer fees. Because the last thing you want to do is take an offer, the buyer put like $300, just a random number, and you just agree to it. And then you find out it's a $2,000 transfer fee and you just cost your seller $1,700. So if you list a property in an HOA, you need to figure out what are the transfer fees so that you know what's the right amount to negotiate in that blank on the HOA addendum. Does that make, but this is covering the case if you don't fill out one of those. Okay. All right. Possession. I'm going to breeze through the last, how many pages? The last 5 pages, but it gets faster. And also, if you guys are here and you need to go at 10, but you want CE credit, that's fine. We'll keep going, and I'm going to go as fast as I can. We'll keep going until we get through the whole contract if you want to stick around. Just as a reminder, please put your license. There's a ton of people on this call, which is super exciting. Please put your license number and your name in the chat if you want CE credit, and you can Venmo $10 to CG Partners, which is a business account. And when you send the Venmo, please put your license number in the payment memo so that then I know it helps me. What I do, I just want to make sure everyone who wants credit gets credit. So I ask you to put it in the chat and also to put it in the payment memo. If you don't have Venmo, that's fine. Just we'll connect later. I'm not worried about it. We'll figure it out.
Who do we Venmo?
The CG Partners. I just put it in the chat.
Okay.
Okay. Possession. So buyer shall deliver, seller shall deliver to buyer possession upon closing and funding or according to a temporary residential lease. So that's Susan, where that part goes. You are exactly right. If you are selling a property that has a residential lease in place with a tenant, you're going to say, you know, upon closing and funding, because the seller's delivering possession to the buyer to the extent that they have it, because they have keys. They're not giving them physical possession, but the buyer becomes the landlord. So, you know, any possession by buyer prior to closing is not authorized by a written lease will establish a tendency at sufferance. Just don't do that is my recommendation. And then consult this is bold and conspicuous because it's super, super important. If you guys do any type of lease, whether it's a buyer's temporary or seller's temporary, please, please, please advise your client in writing that they need to connect with their insurance agent to make sure that they have proper coverage. You know, the day that they sell the property, their homeowner's insurance, the buyer will get homeowner's insurance and technically the sellers won't. And so they might need to get basically like a rental coverage, right? So that their personal property is covered. Again, that might be wrong. I'm not an insurance expert, which is why we need to advise them in writing to please talk to their insurance agent and ask them what type of coverage that they need. Okay. And then this was new before, smart devices. This is basically instructing the sellers before they go, how they need to convey like basically access to the buyer of all the information to get to all of the technical smart features of the home, which was a good addition and is very clear about what needs to happen in terms of conveying the smart devices and all the information and logins and things like that. Okay, so this is a change, and they're trying to be even more like unambiguous about the fact that this paragraph, and this is a total change. They took all the language that was there before and put, this is all new, and it says this paragraph is intended to be used for only for additional information items. And an informational item is a statement that completes a blank in a contract form, like if you run out of space, discloses factual information, or provides instructions. Real estate brokers and sales agents are prohibited from practicing law and shall not add to, delete, or modify any provision of this contract unless drafted by a party to this contract or a party's attorney. We had an issue recently where an agent had written something in special provisions at the instruction of their client, but they got instructions over the phone. And so we had no paper trail that the client had actually like told them to write it. And it was a problem. So what you guys need to make sure to do is that if you're going to write anything into special provisions, which you can now see is very short, if your client wants you to write something in there, you need to say to them, please send me an email that says exactly what you want me to write in there, or have your attorney send me the language and I will stick it in there. Like, we're allowed to do that at the express instruction of our client, but we can't make stuff up because we're not attorneys. If you have something that you do want to write in there, please call me or call Angela and we can help you with the language. The good news now, I have learned this in the past couple of months, is if you call me, I can always run it by the Momentous attorney and as a backstop, and they are giving me such good and awesome information and advice. So it just takes a lot of liability off of you and off of Briggs Freeman. So please, please, please don't do that. It was an expensive mistake to write that stuff in.
What about a deadline? Is that okay?
Deadline? I mean, you're saying like this offer expires automatically at 5 p.m. on Thursday, February 1st. I think that's fine. Yeah. And I mean, if you want, I can write you an email that says like, you can always write this in there, yes, that's fine. Because then you have like, I'm an attorney, right? And I have told you to write it in there or said you can use this language, but I think that's fine. But you have to be careful again, because you're not attorneys. Like sometimes I see language like that and it's like not a complete sentence or it doesn't really make sense. So if you want to write something like that in there, just run it by me or your manager the first time, and we'll like make sure the language makes sense and then you can use it. Does that make sense? Yeah.
Yeah.
Okay. So settlement and other expenses, there's no changes here. This says, what's the seller going to pay for? This is our famous 12A1B, where if the seller is providing a closing cost credit to the buyer, like maybe in lieu of repairs, you can put that number in there. Please, please, please don't put a number in there without talking to the buyer's lender first. There is a maximum amount that buyers can get back in credit. And so your lender would be able to calculate specifically, basically to the penny, like what that number is. And you don't want to negotiate for $20,000 and then find out that the buyer only has $16,000 worth of closing cost credit that can be applied for, because you're losing the benefit of that $4,000 you negotiated for. So you could, if the lender's like, it's $16,000, but there's $20,000 worth of repairs, you can make the seller do some of the items, some of the repair items, and then you just put the $16,000 in this blank. Does that make sense? Okay. All right. And then this is what the buyer is going to pay for. Pro rations. This is where it provides that taxes for all of this stuff. And there is a change here. And it basically says it adds rents and regular periodic maintenance fees and dues, including prepaid items. Those are new. That's new language. It basically says everything's prorated through the closing date. And then it says also, if taxes for the current year vary from the amount prorated at closing, the parties will adjust the pro rations when the tax statements for the current year are available. If taxes are not paid at or prior to closing, buyer shall pay taxes for the current year. This is super. There's a document also that they sign at closing that says it's a tax proration agreement, saying that if what they prorated on was off, that the parties will kind of fix it later. So if you're in that situation now where you had buyers, you had, if the buyers gets the tax bill and what the seller paid for doesn't cover what the seller actually owed because the taxes increase, like the buyer can go back to the seller and say, hey, you still owe me this. And there is a document that they signed at closing that said, I will agree to pay this. So if you're in that situation, reach out to the title company and they can help you figure out what the exact amount is that the seller owes to the buyer based on what was paid. And you can get that evened out if you want. So that probably could be really relevant right now since the values increased so much. And last year, title companies were prorating taxes on the 2021 values, and the 2022 values probably increased a lot. So, okay, casualty loss. This governs what happens in the event of a fire or some other casualty. We got real familiar with this paragraph. Some of you guys remember when the tornadoes came through Dallas. So it just provides how do the buyers or sellers handle this if something catastrophic happens to the property while it's under contract. This is the provision, the default provision. If buyer fails to comply, buyer's in default and seller can enforce specific performance, seek other remedies available by law, or terminate this contract and receive the earnest money, right? And then all parties are released. If they sign that Texas Association of Realtors release of earnest money form, that's like a full release of liability for like everyone involved. If seller fails to comply, they're in default and buyer may enforce specific performance or seek other relief, basically sue them to like comply or terminate the contract and receive the earnest money. So that's the default provision. Any questions? No? Okay. Mediation. This basically says if there's an issue, we're agreeing to mediation in advance. It says anyone who prevails in any legal proceeding related to this contract is entitled to recover reasonable attorney's fees. Escrow agent. So there's no changes in this paragraph other than the fact that escrow agent is now a defined term. But this is basically the paragraph that's, the CYA for the title company saying they're not a party. They're not liable for the performance or non-performance. They're not liable for interest. And then it says, at closing, the earnest money will be applied first to cash down payment, then buyer's expenses, then any excess. If no closing occurs, then, it says what the title company is going to do, request basically a release from everyone. This is the paragraph you need to know if you get into a fight about the earnest money. And if you're in that situation, we can kind of go through it together, but you basically have to, one party says, I want the earnest money. The other party says, I want the earnest money. You both make a demand. The title company basically has to sit on it and notify that each party has made the demand. And then if nothing happens in 15 days, if they make a demand to one party and they don't respond, then after 15 days, they can release it. But usually, when both parties are fired up about wanting it, they've both made the demand and the money just sits there until they can come up with an agreement. But if you get in that situation, we can go through it. Just remember that this is the paragraph. And then this sentence says, any party who wrongfully fails to sign the release will be liable for damages, the earnest money, reasonable attorney's fees, and all costs of the suits. So basically that says if you have someone who's, is wrongfully refusing to sign, you just have to let them know that if they dig their heels in, like they could be liable for all of these things. This basically provides that, all covenants and representations and warranties in this contract, which the seller is making, survive closing. And then if any representation is untrue on the closing date, seller is in default. And then this interestingly says, unless expressly prohibited by written agreement, seller may continue to show the property and receive, negotiate, and accept backup offers. It's interesting that that's in there, but it's just good for you guys to know, because a lot of times agents do get mad that the listing agent is continuing to show the property, and they have like every right to do that. Okay, so this is federal tax requirements. If the seller is a foreign person, there's like a whole additional set of steps that the title company has to take. And there's it's called FIRPTA. I don't even know what FIRPTA stands for, but it's an affidavit that has to be signed. And then some of the funds have to be held back to make sure that the seller pays their taxes. So just be aware of that if your seller is a foreign person, that there's going to be some additional steps, and let the title company know like in advance. Okay, so this is a change and you guys are going to be super excited about, but you will see that they have added, with a copy to the agent blank down here. So, we never want the opposing, the information for the opposing side to be blank, because this is the notice provision. So we want to know who we can notice. So when you're writing an offer, at minimum, put the listing agent's contact in there. And then it's up to the listing agent to fill out what they want here, right? Because this is if there's ever a legal dispute, if anything ever goes sideways, this is who you have to give legal notice to. So you guys should be mindful too. If they put to seller at, the seller's email and then the listing agent's email, when you send like official legal notices, like terminations or, things like that, I would send it to both of them because that's giving legal notice. And then of course, on your side, you want to make sure that it's filled out. You don't really, if you're writing the offer, you don't really want you to be the only contact for legal notices, right? You want someone else who's a party to who's actually a principal in the contract, your client, to be notified as well. Does that make sense? My point is, please just don't leave it back blank. At minimum, when you're writing an offer, put your email and the listing agent's email, and preferably you would include your client's email as well so that legal notice is given that way. And then be really mindful when you're giving actual legal notices in the contract, who you're sending it to. Does that make sense? Okay. So then, this paragraph is like, what are we including here? What are we incorporating by reference? You guys are always going to have to check this box and write addendum for square footage or square footage, whatever it's called. I'm sorry, I can't remember the name off the top of my head, but you need to write that in there so that's incorporated, right? And then just make sure you're checking all the right boxes. And then if they have an attorney, you fill that in. They did change, this used to say salesperson, license holders, and now it says real estate brokers and sales agents. I think that's just more clear for the consumer. And that's pretty much the only change. Obviously, the effective date is the date that the last of the two parties signs and delivers it. I've told you guys this story many, many times, but we had a deal and I was in a plane on the way to San Francisco and we had fully agreed to it. And I was just waiting to get executed documents back from the buyer. It was my listing. And when I got off the plane, I had an offer, a better offer. So I called my seller. We immediately rescinded our counter offer to the first buyer. And she was like, well, I have it executed. I have checks. I have everything. And I'm like, yeah, but you didn't deliver it back to me. And delivery is the final component, right? So that was a huge miss because we ended up going into multiple offers and ultimately that first buyer got it, but they paid $25,000 more because the agent didn't send me the email with the executed contract, which was tough. So just remember, delivery is the final component, right? It doesn't matter if you have it executed and the dates are all filled in, you got to get it to the other party. Okay. And then you guys know, obviously, it's just one thing I like to point out, if it's a different broker on one side and us on the other, if it's an intermediate situation where it's our listing, none of this is going to be filled out because you can see it says other broker, but here it's all the same broker. So listing agent goes up here and then buyer's agent goes up here. So on intermediary, this side is only going to be the side that gets filled out. Okie doke. Whew, okay, that's all I got. Is that any questions? That was a lot of fast talking.